Hi, for those members I've not met, my name's Andy Slee. I'm the new Chief Exec of SIBA. I've been in the industry for a long time and I speak to lots of breweries, and there's a lot of concern around the industry about what the future might hold. As part of the repackaging and re-promotion of the brilliant service that Napthens, our solicitors, offer to all members as part of membership, I thought it was worth having a chat with the business recovery partner at Napthens, Grahame, who deals with companies in distress, to talk about the things to do if you're concerned, and then what might happen as the process goes on from there. So Grahame, just from we hear a lot about the cost of living crisis and inflation. What are you currently seeing in your field at the moment?
Okay, so what we're seeing is there's been an increase in creditor pressure from various different directions. So we have an increase in pressure from the revenue. People have built up revenue debt over the pandemic, really. The revenue is now issuing winding up petitions, and that's coming at the rate of 70 or 80 every other week. We get weekly stats on that. We also see that some of the high street banks, those that have given bounce back and SIBAs loans, are also starting to petition. But one in particular is doing batches of 50 or 60 every few weeks. So we're seeing the creditor position hardening a little. The good trading will be out of the way in January, and we think there'll be a real hardening of positions after that.
Okay. And are you seeing anything different, particularly in the hospitality and brewing sector, or is that just the same across the board?
It's the same across the board, really.
Okay.
We think there'll be particular issues because of the seasonality of the hospitality and brewing, but across the board, creditors are starting to harden their stance.
Okay.
So yeah, it's going to be a difficult 12-24 months, I think.
Okay. There's no brewer that I've spoken to in the last weeks and months that aren't concerned about the future in terms of everything we see from a macroeconomic point of view. If brewers and SIBA members are concerned, what should they be doing? What's best practice?
Well, it's essentially good corporate governance. So we would hope that they were doing these things in any event, but it's always worth a reminder. So I'm starting from the position that most members will be SME businesses. So we will have a board of directors that run the company. That board of directors should meet regularly and discuss all the concerns that they may have. They should be keeping financials under review. They should be creating accurate real-time management information insofar as possible, working with their either in-house or external accountant in order to produce genuine management information. And when there are concerns, they should be looking to take early legal advice or early accountancy advice in order to highlight what the issues are. That doesn't mean that things are inevitably going to go wrong, but what it means is that if things do go wrong, they have a defensible position to demonstrate that decisions have been made in the right way, professionally, with the right information. Records of this process need to be taken and put away for a later date.
So you're saying record keeping is really, really important at any stage?
Absolutely critical. So we'll speak to directors regularly who have probably done the right things but can't evidence that they've done the right things. So if you don't have the evidence, it's almost as bad as not doing it in the first place.
Okay, so that's things like board minutes, meeting minutes, regular reviews of accounts, etc.
Exactly. Reviewing the management information and recording your decisions based on that management information.
If worry becomes concern, what's the next step there?
The next step would be to keep on with the record keeping and to focus again on the professional advice. So to sit down with the accountant, the incumbent accountant, and set out some 3, 6, 9 months cash flows to work out exactly what we're expecting from the business, but to keep that under review and if we're not hitting targets, to go back again and look at what is realistic and continue to look at what's realistic. If we get to the point where we have genuine concerns, there are things that regularly we see in insolvent companies that could have been done better, had a little bit more information been available. So one will be the way in which the directors and shareholders draw their remuneration. It's common for SMEs to draw remuneration as dividend, so payments to shareholders from profit, as opposed to paying wages PAYE. Now there's a large tax advantage in that process. However, what that actually does on a technical level is to create a director's loan account which becomes more and more overdrawn until a profit is declared and the dividend is declared on the back of the profit, and that is then credited off the account. Now, often people don't understand that, and if a company goes into a process, that is money that is immediately owed back to the company. So that can be a bit of a fright. We also have common in this industry, well, there'll be kit on finance, and that finance will be personally guaranteed. So we need to consider when entering contracts whether we really need to personally guarantee, or whether we can go to a different finance provider and cut a better deal or a different deal.
I'm in regular contact with Napthens, and a comment from one of the partners that really hit home to me was very often companies that are in difficulty leave it too late to ask for professional advice. Would that be your experience in dealing with this?
Yeah, almost 100% of the time.
Yeah.
You have two sorts of clients. You have those that work closely with their accountant and seek very early advice, and you have those that only seek advice when something catastrophic happens. So receipt of the winding up petition,
Okay.
The finance company coming up to repossess the central piece of kit. So yeah, almost invariably the answer is if you've sought advice 8 to 10 weeks earlier, there could have been something that could be done. The revenue can be dealt with. You can negotiate a time to pay agreement. It's about sharing information and getting yourself off the top of the list.
Okay. And I think it's worth reiterating at this point, as part of SIBA membership, Napthens offer a 1 hour free consultation on any individual legal matter that you might have. So there's an opportunity at no cost to you to give Napthens Helpline a call as early as possible, and they can help point you in the right direction. And I think that's if you are in that situation, hopefully you're not, but if you are in that situation, it's really sound advice. So let's turn now, Grahame, to if things do go wrong, what could members expect, and what sort of help could Napthens provide?
Well, if we get to the point where the advice, either legal or accountancy, is that we need to be speaking to an insolvency practitioner, the very first piece of advice is to do that early, and to talk to someone that is familiar with your situation, so is familiar with the sector, and also familiar with your other advisors, with us. So we're very pleased to introduce insolvency practitioners with whom we work regularly, and who we are confident will be able to understand the situation in your particular industry, and will ask the right questions, because there's two levels of issue. One is the issue in which the corporate entity is experiencing, and the other level of issue is the issue which the director shareholders will experience if the company has to go into an formal insolvency procedure. Now, it's a little bit like making a will. The fact of making a will does not mean that you're immediately going to die, and the fact of having spoken to an insolvency practitioner does not mean that a formal insolvency is inevitable. But what it does do is it prepares you properly, that if the worst happens, you can get yourself in the best position. And there's various routes under the Insolvency Act whereby a director can become personally liable for debt in the company, as I've explained, the director's loan.
Yeah.
That is purely an accounting practice there is a point at which the benefit of paying lower tax isn't worthwhile as weighed against the risk of going into an insolvency procedure and having built up an overdrawn loan account. So there's no hard and fast rule, but there's a tipping point as to when this isn't good practice anymore. So that's the first easy thing to consider. Once a company, and any company, not just in this sector, approaches the point at which it knew or ought to have known it wouldn't escape insolvency procedure, the director's duties change from being duties to do the best for the company to being duties to do the best for the creditors. Now, if directors allow the company to trade past that point, there's a risk that an insolvency practitioner in due course will consider this to be wrongful trading, and the deficit incurred from that point forward can be claimed back as compensation to the company.
So that's a point of law. So in law, what does wrongful trading mean?
Wrongful trading is trading on past the point which an adequate director knew or ought to have known, so both subjective and objective, that the company would not escape a formal insolvency procedure. And the reason that's important is because the company will continue to incur debt from that point onwards. So every further day, that's debt that it shouldn't rightly be incurring. So that can be borne by the directors in due course.
So that's another reason again to contact early, to make contact and seek professional advice as early as you can, and not just close your eyes and hope it goes away.
Exactly.
Yeah.
Exactly.
Yeah.
Because there may well be a rescue procedure that could be put in place, but trading on to the point where someone else, a third party, stops you is almost never the right thing, because there will always be a period whereby the reasonable director would have stopped.
So in terms of your experience in the sector, heaven forbid, we don't wish this on anybody, but if anybody is in that desperate situation, what differentiates Napthens to other professional advisors that you might come across?
Well, I think it's the proactive advice to grasp the nettle. What we need to do is, we are where we are, let's get an understanding of the situation that we are in, let's talk with the incumbent accountant, let's produce the best management information we can, and then let's make a decision based on the information and the knowledge of the sector. And also let's work with the appropriate professionals, the appropriate insolvency practitioners that understand the sector and are motivated to help.
Okay, and that's so that you have a good network of people, and so do these people work in sectors, or do they work generally across all industries? So would it be an advantage if you had somebody that was used to dealing with brewers in this situation, for example?
Yes, if there is to be a rescue of the business of the company in whatever format that may be, having someone that actually understands how the business works is a huge advantage.
Okay.
And by the same token, having someone, even if there isn't a rescue available, having someone that has a bit of sympathy and understands the challenges that the members will have faced over the last 3-4 years, it is also quite reassuring that people like to feel that the professionals have understood what happened and why it happened.
Grahame, so when worry becomes genuine concern, and for the benefit of the SIBA members who may not have access to professional advice, what are the legal obligations on directors of a company?
Okay, so the directors of the company have an obligation to the company to do the best for that company, and that is essentially to increase the value to member shareholders. There is a point in time at which that duty switches from being a duty to the shareholders, members, to being a duty to the creditors. That point in time is when the director himself knew, or a competent director would have known, that the company would not escape an insolvent liquidation. Now, at the point at which the company would not escape an insolvent liquidation, the director may become personally liable for some or all of the debt in the company. And once it goes into an insolvency procedure, a liquidator or administrator will look back and try and pinpoint the date and work forward to see the extent to which creditors have been harmed since that date, and that number can form a personal claim. Now, this isn't just a textbook claim. I'm working on similar matters at the moment for directors that have had large claims, approaching £1 million claims, because the liquidator has taken a view that from a particular date they should have known that they wouldn't escape liquidation, and the claim is essentially for all the harm caused between that date and the date of liquidation.
So what you're telling me then, Grahame, is if you are concerned, seek legal advice as soon as possible, and don't hide away thinking the problem's going to look after itself.
Exactly. If there's one message, it's to grasp the nettle.
So if you were to give one piece of advice to SIBA members, and we have 700 members literally from Land's to John O'Groats, all of them are currently trading, but obviously facing the future with a degree of trepidation, what would that advice be?
I think it's to be realistic, gather together the best management information that you can.
Hopefully people will have found that really useful. There isn't a brewery that I have spoken to in the last few months that isn't concerned about the future, and the objective of this is not to wish people into receivership or administration or whatever. It is to provide good sound advice as part of SIBA membership in what can be a very lonely situation if you're not careful. So Grahame, thank you very much indeed for your time. It's much appreciated, and don't take this personally. I hope nobody contact you. I hope I don't need to speak to you again.
Okay, well, it's a pleasure, and you know where we are.
Okay.